Hello and welcome to today's webinar. Thanks for coming and joining us again if you are returning. My name is Samantha Winters and I will be hosting today's topic. But before we get started, switch screens, note that microphones are muted, but we welcome you to type your questions into the Q&A box anytime. We really consider this webinar to be more town hall style, so don't hesitate to raise anything at any point. If we don't get to them, we will do our best to circle back towards the end. A few things our lawyers make us say, primarily that this webinar is for informational purposes only, and that this is not a substitute for legal advice. Now, let's get to the topic of why we're all here. How to issue second opinions when your patient is out of state, what you need to know about these episodic exemptions and how they've evolved over time. We're joined today by Les Trackman, who has been tracking these pretty closely over the past few years now. For those who haven't met Les before, let me give you a quick introduction. He brings over 4 decades of experience from working with startups to strategy and healthcare and technology. He's founded and led multiple businesses, is a best-selling author, and a professor at Johns Hopkins University, Carey Business School, where he was actually once my professor. Les is also an attorney, which is really helpful when you're digging through state law. And Les, you recently presented this research that we're going to talk about at the American Telemedicine Association's annual conference, right?
I did, yes.
Great. And you'll be speaking again in December at the policy conference on the same topic.
Right, that's in DC. Yep.
Great. So if you haven't attended that conference before, it's filled with great information that spans a lot of different topics, but of course, Les will be there. So we highly recommend it. Did I miss anything before we hop into it?
No, I think you're good.
Okay. So since some are joining us for the first time, even, some may have been here before, but it's always nice to have a refresher. So maybe you can begin by reminding us of some of those legal principles that we need to keep in mind as we go through this discussion.
Sure. So this is straightforward, but sometimes a little frustrating because of what it means. But generally, a provider, a physician, can only practice medicine in a jurisdiction in which she or he is licensed. Now, you can be licensed in multiple jurisdictions, but each state, actually each jurisdiction, including states and territories of the US, have their own licensure regulations. And the law that controls is the law of the location of the patient. And I use that word location very importantly because it is literally the location, not the home, not the venue, but the location of the patient. So we have these crazy situations where a patient gets in her car and drives over the state line, parks in a parking lot, and then does a consult with the doctor who happens to be located in that state. That is all legal according to the way the laws are written today. What we're talking about when we talk about remote second opinions is this thing that we typically refer to, and many of the states refer to it as episodic or occasional, which is different than general telemedicine. General telemedicine is, we'll call it a continuum of treatment. It's as if you were seeing your doctor, going in for something that was wrong with you, you're seeing your doctor, and then having continual conversations and or meetings with that doctor. That's telemedicine. This episodic, which is a subset of telemedicine, typically if it's remote, is something that happens on a very occasional basis, sometimes only once in the form of a second opinion. The way the law is written, it favors centers of excellence or deep level specialties. So not just institutions, but providers who are specialists, typically providing a relatively scarce commodity, which is that specialization. And what the states are acknowledging is that specializations are not homogenous across the country. In fact, they're not homogenous across a state either. And so to get access to the patients that need it in that state, the states have created these things called exemptions, which we'll talk about as we go forward today.
Great. Now, you kind of just covered this when you were talking about how episodic is not the same as telemedicine. but you're constantly reminding me of this. So is there anything else that we missed that you want to expand on?
Well, I think it's important to note that that the world of technology really is changing the geopolitical environment. Sometimes we wish it would change it more than it is, but it's changing the environment, meaning that these borders that we have, these state and even country borders that we have, are not really relevant in the world of technology. And today, when we talk about the cloud, or we talk about telemedicine, or we talk about electronic video, we're basically in a world that's different than the way that our borders were drawn and written. And when we talk about episodic, it's a subset, and it's a different type of exemption that the states use because it's less invasive, if you will, to that state's legislation.
Great. So before we jump into the specific episodic exemptions and the types, I wanted to first ask you about the other legal strategies, because we get questions about those as well. And we hear everything from, educational, educational being categorized as a potential exemption, so to speak, or a doctor being registered in every state as being compliant with the law. Can you run through some of those and how they differ?
Sure. So when we first started out looking at this, because obviously remote second opinions are of interest to us, we were frustrated by what we found as the law. And so we did some digging, and what we saw when we did some digging were a couple of things. One was, at that time, no longer there today, but at that time, the Cleveland Clinic, which was, I'll call them the granddaddy of the remote second opinion business, was using an exemption that they called an educational exemption. Basically, what they were saying is that issuing a second opinion was simply for educational purposes. It wasn't really the practice of medicine. We did some digging into the law, and that didn't comport with what we saw as a law. And so we didn't like that. It turns out that their new legal counsel, came in and changed what they were doing. But they had this very long agreement, I think it was 16 pages long, that every patient had to sign that said, hey, yeah, this is just for educational purposes, which didn't sound really kosher to me, and it wasn't. So the educational exemption really doesn't exist if you're truly giving a second opinion, which is patient says, I've got this chief complaint. Doctor says, here's what I think you should do. That is the practice of medicine, short and sweet. And so education doesn't work. Along the way, as we were doing this research, what you're seeing on the screen is the Interstate Medical Licensure Compact arose. And these were the states also frustrated a bit with the federal government not being able to issue a proclamation across the country. So instead, what they said is, we'll get together and we'll try to make it easier, again, to try to help the patients in need in our states by creating this consortium or compact between the various states. And as you have on the screen, there are 42 states. So most of the states now are members, with exceptions of both coasts, which often happens in our country. But these states then allow a single registration for you to get multiple states equivalent of licensure. It's not exact licensure, but it's equivalent of licensure. The problem with this one was it didn't do away with you having to pay a fee to register in every state. So effectively, you didn't have to fill out the forms, but you still had to get a license in each state, and that cost a lot of money. So the only ones who were using this were telemedicine firms or people that were, or institutions that were giving second opinions, we're giving opinions, I should say, practicing medicine across many state lines. So it's expensive, it was burdensome still, but this made it a little bit easier. The other thing we heard when we were doing that research was that these entities that we call concierges, or some of the groups that were saying, look, we'll set up shop within your institution, Mr. or Miss Hospital. And what we'll do is we'll bring you patients. They'll mostly be our members that we'll bring to you. And don't worry about where they are, because we'll provide you with the buffer that will basically take the liability off your hands. And we heard that from directly from several concierges. And that also did not compute. It does not work, because the reality of it is the law is written very clearly to say It is the liability of the provider, the physician, who issues the second opinion or who provides medical advice or medical treatment across state lines. That's liable, no matter who and what is trying to insulate them from that. So none of those things work. So we were stuck with okay, now what are we going to do? And we dug into the law, and what we found was there were an increasing number of states that were providing clear exemptions. You had to follow their policies, but clear exemptions for what we call this episodic or occasional, in many cases, second opinions that were going to be issued for patients within their state, located within their state, to enable them to get access to this scarce deep level specialty that they needed. And so the states were taking it on their own, not just with the IMLC, but also with their own laws, with their own exemptions to do that. And they do it in a bunch of different ways. And we're going to talk about those ways today.
Right. Quick follow-up question to that, because we've heard or we've seen from some of these states that they require that you have a pre-existing relationship with the patient as well. So if you're licensed in that state through the IMLC, but the patient is out of state, do you still need that pre-existing relationship with the patient? Confuses things a little.
So what I would say is this: there are several states that actually very clearly say that the local physician must be engaged in some manner in whatever the diagnosis is or the treatment recommendation that's made to the patient, and that in some states that must be a physician with an existing relationship with that patient. So it can't just be I've got somebody that I've never met before that has a license that I'm going to involve in this decision because they're somehow contracted to do that. That doesn't work in every situation.
Yeah. Okay, great. So we have seen this come up a lot, and it is changing all the time. So you can go to the website. We'll share it as one of our resources and track as these change. But as Les mentioned, when you're dealing with an occasional case, it might not be cost advantageous as well. So let's touch quickly on an article from our friend Nate Lackman that came out this past February in Fierce Healthcare. We heard from some of our colleagues after this came out that they read it and they thought, okay, second opinions, are they completely off limits now? But then you had a conversation with Nate. And so from your perspective, what is the takeaway, and how should hospitals interpret the article and apply the guidance that is discussed here?
Yeah. So Nate, as you may know, is now the president of the ATA. So he's a voice, an industry voice that people listen to. And being that he's a lawyer, he authored this article that spooked a lot of people. In fact, several of our clients who we thought were over this already, that got the exemption part of this, came back to us and said, "Oh no, what do I do now?" So let me parse this out a little bit for you. So first of all, what Nate quoted was a 2010 case. It's real, and it is probably the last word that we've heard that's on point with this topic. So in this case, it was a pathologist in the state of Washington working for LabCorp was sent a pathology sample, did an analysis, contacted the patient who happened to be in Idaho, and told that patient what the diagnosis was. You don't have to worry about what happened to cause this lawsuit because that's not necessarily relevant, but there was an action taken against that pathologist in Washington to say that that pathologist had practiced law in Idaho without a license, potentially criminally liable for doing that, potentially civilly liable for doing that, certainly violating the laws of the state of Idaho as far as this was concerned. And the case fell just that way, which was they found this physician in Washington liable. Now, let me peel that back a little bit. So first of all, that doesn't mean that there aren't exemptions that are valid that would have made this work. In fact, in this particular fact situation, that pathologist in Washington never contacted the local doctor of the patient who had initiated the pathology read in Washington. This whole case would have turned completely differently if that doctor, that pathologist in Washington, had a conversation, perhaps first, but at least had a conversation with that doctor of this patient in Idaho. That would have changed, according to the way this judgment came down, that would have changed the whole judgment altogether. So there was no contact whatsoever between that pathologist and the local physician for this patient. So Idaho, and we can talk about it later, but Idaho has lots of exemptions, or very clear exemptions, for how this could have transpired. And this exact same situation could have worked out exactly the same without any liability on the part of that doctor if they had known about what the exemptions were, or even done some common sense work, which would be to talk to the doctor of this particular patient rather than just issuing a report to the patient themselves. So what we try to do, and I sat on the panel that Nate suggested, and I'll be on a panel again, as Samantha said, coming up in December in DC. What we suggested is these exemptions are alive and well and work very well, and they are not fringe. They are right down the middle of the bowling alley, if you will, and we can follow those. And if we do follow those, we don't fall into any of these categories, despite the fact that this did spook people. And perhaps it should spook them into compliance. It's just like doing what the law says, right? If you speed down the road at 100 miles an hour, you are likely either to get in an accident or get arrested for speeding. That's the same exact scenario here. But if you go under the speed limit, you'll do just fine. And that's the situation, right? We got to give you what you need to do to be under the speed limit. And that's what we're trying to do here.
Yeah, I think that's helpful to understand that, you know, if you follow the best practices, then you're still in compliance, and that this wasn't really talking about that circumstance.
I think Nate's great. He's a really good lawyer, well thought of in the industry, but it's really easy to spook people by saying, hey, there's a case and they held this person liable. That has a chilling effect. And what we're trying to do is raise the temperature a little bit, reduce the chill, and give you a really valid approach to how this happens.
Exactly. Great. Okay. So sorry.
A question just came in on that one,
Sure.
Samantha. Maybe we should deal with it. The question is, in this case, could the pathologist have been in compliance with the law if they had contacted the local doctor before or after talking to the patient? I'd have to look carefully. Sorry, I'd have to look carefully at the laws of Idaho, and I have them in front of me here, so I can look at them in a minute. But I think this case would have changed completely if that pathologist had either before or after talked to that doctor. I think it would have changed completely the complexion of this case. What we would recommend, and you'll hear this later, is that at least concurrently with that, there should be a connection between the two. And it should be a team, right? It should be the pathologist teaming with the local doctor for that patient to provide that patient with the best care possible. And so that's our recommendation. We can get very specific. Each state's a little different, so we can get very specific with that state. But good question.
Great. So looking at the episodic exemptions, you've been tracking this now since 2023, so a few years now, right? We've seen a lot of updates, and we've seen some trends emerge in similarities over some of the states and how these are occurring. So we have begun to, or we categorize them and visually encoded them into this map for ease of understanding, so to speak. So if you have seen this before, I did want to point out that we previously had a category called ambiguous, and we've now categorized those couple of stragglers or ambiguous states. So that is one update that you'll see here. Now it is interactive. I'll drop the link here in the chat in a moment if you want to explore or hover over each state to see which states do have some limitations and what type of exemption they are. So as I pop that into the chat, maybe Les, you can walk us through, again, remind us what is an episodic exemption, Give us maybe a little background and an overview of these categories and how they came about.
Yeah. So first, let me talk about the ambiguity stuff that Samantha said has gone away. So despite the fact that I'm a lawyer and lawyers live in ambiguity, right? If you ever ask a lawyer a question, they said, it depends. I decided as a business person first, with my business hat on, that we had to get rid of these ambiguities. So what we did was we took an approach that simply said, if you are required to get a license in a state, then we're going to say that's a prohibited state from doing these remote second opinions. If you need to notify the medical board, either pre or post, that you're issuing an opinion, or your local physician that you're partnering with has to tell the medical board that you're issuing an opinion, we called that prohibited as well. We thought that was an undue burden on that. And then thirdly, actually, there's four. So the third is, if you can't speak directly to a patient, either in conjunction with a local physician or at the request of a local physician, but if you can't issue a second opinion directly to a patient, we call that prohibited. And then fourth, because we are in business, at least capitalists at heart, if you can't charge money for that second opinion, we also consider that to be prohibited. So instead of being ambiguous, those are just prohibited as far as we're concerned. Now, there are, in each of those states, there probably are ways you can shave that a little tightly, and you can issue a second opinion. But the ones that are in yellow or orange there on your screen are ones that we would simply say, if you're going to create a national program, that you be very cautious about those states, or perhaps even just say no to patients in those states at this point, which means tell them to drive across the state lines, park in a parking lot, and you can issue them a second opinion where they are.
Great. So, sorry, go ahead.
I was going to say, and then there are the three categories that that Samantha has listed on the right hand side of your screen, and they generally fall into this permitted in conjunction with a local physician. So involving a local physician, that question that got asked about Idaho, could, if that state, now again, I have to look up Idaho, but if that state has what we call in concert with exemption, that would be sufficient before, after, or otherwise. There's one that says permitted at the request of the local physician. So a local physician has to issue a request, and we can talk about how we make sure that that gets done correctly. And then there are several states, I think it's down to 3, that allow you to simply go in and issue a second opinion episodically, even without a local physician. But those are 3 states. And we're going to, in just a minute, we're going to talk about our suggestions for how you go about this so that it's foolproof. So you don't have to think about this except for those 4 states.
Yeah, that's great. And previously we did have just green for does it have an episodic exemption or not? But we have gotten more refined into the 3 categories that Les is going to explain here in a moment. So now it's a little bit more dynamic, which I like. So let's start with one of these states that we like to call our problem state. Maybe we can kick off with Utah as an example of a prohibited state.
Yeah, so Utah is a classic case where basically it says you can do this, you can issue a second opinion for a patient located in Utah, but you can't charge for it. And so as far as we're concerned, that hits that no provision, and we X Utah out from issuing at least commercial second opinions.
Great. And there's 5 of these problem states. So again, you can hover.
Oh, 5, sorry. The 5, you count Virgin Islands, I guess it's the 5th one.
We forget about that one because it doesn't, our map doesn't let us edit, but it is on the website when you see it.
Yeah.
So, okay. So we have 28 of in concert with. This represents the largest category. What does in concert with mean?
It means involved. So this one means that you should make sure you know the name of, and that you make sure you have connection with, whether that connection be synchronous, asynchronous, or otherwise, in writing, in video, in phone calls, that you have you've made a connection with the physician who, in best case, has a physician-patient relationship already with the patient in question. So you don't have to have them ask you to do it, and you don't have to make sure the timing is exactly right. You simply need to involve them. Now, let me peel that back again and just say, let's be logical about this. If you're a doctor in New York and you're issuing a second opinion to a patient in California, it makes really good sense for you to ensure that somebody's going to be there to help this patient if they need them. So knowing who that physician is sort of incumbent upon you as a qualified provider. So I don't think this is, the law says you got to do this, so you do it. I think this is a very logical thing to do. And I think if you follow logic in many cases, you'll be off the hook. And again, I think Idaho or that Washington doctor in Idaho would have been off the hook.
Do you mind just taking a moment and explaining how some of our clients are able to document this in their process and how they go about it? Because that question comes up a lot. How do I do that?
So we think it's really imperative, and obviously we have software that handles this, but you should always require that you have the name of the local physician for that patient, even if that wasn't the physician that referred them to you. In our system, you can put in multiple, we'll call them local physicians, so multiple California physicians, even if you're not in California, but document it. That's really the important part, is document it, have that information. If you need to validate it, get their MPI number and check that against, are they really a California doctor, and talk to them, have a conversation and or correspondence with them so they really exist.
Right. And I know some invite the local physician into the process. They can view the opinion, they can interact. So that's good to see.
Yes.
Okay. So our next example state is Alabama, which permits in concert with the local physician, but then they've added a limitation to the frequency, less than 10 days in a calendar year. So
and I think there are 6 or 9 of these states now.
9 now, actually. We've seen a
9
couple
states.
more. Yeah.
So there are 9 states that actually have specific numeric limitations, either to frequency or duration. So there's two categories now. Duration is a newer one that we've seen, but frequency is one that's been around for a little bit. So you can issue these second opinions. This is an in concert state, so you can do this as long as you involve the local physician. But you as a provider are limited to only doing this by the letter of the law for up to 10 patients in a calendar year and up to 10 days total in a calendar year. So somehow you need to keep track of that. In our system, you will have that tracking capability. So that's built in. So you'll be able to know by provider what patients that provider has provided this for. This is not, people ask about this all the time, but this is not a burdensome requirement for a particular provider to provide a second opinion for 10 different people in a state. If they're not licensed that state, that's a lot. They'd have to be in business of doing second opinions sort of every day in order to make that happen, just by statistical approach alone. So it's not a big deal, but we keep track of that so we can make sure that doesn't happen. So before you assign a case to a doctor who's done 9 opinions, you might want to look at that and just see if they've given that many opinions in that state.
Yeah, I think that's an important clarification, because sometimes when we are discussing a second opinion program with a hospital that might be launching it for the first time, there is some confusion that, okay, so our hospital can only do this 10 times in Alabama, which really limits you, but really it applies to each physician, right?
Each provider. It is a provider by provider regulation. Another question just came up, and the question is, in Alabama, this law that we've got on the screen talks about telemedicine, and that is in fact correct in this particular case, because the law that controls in Alabama is you're doing this remotely. You're not going into Alabama to do this. Alabama law says you can't come into Alabama necessarily to do this. There's some fluctuation in the law right now. The law has changed a bit in Alabama, but this says if you're doing a remote second opinion, you're subject to the telemedicine requirements here. So you fall into that subset of telemedicine, episodic telemedicine, and that's why this particular provision applies.
Yeah, great question. Keep throwing them in there for sure as we go through. I'm always confused about the differences in each state because each state's different in where you can find these things and how they're evolving. So,
Yep.
okay, so Mississippi is different. You have the episodic exemption, but only when requested by the local physician. So what does that mean?
Yeah. So you have a number on this one of how many states are requiring
18. Yeah.
18 now. So this is becoming more popular, if you will, if you want to use that word. So this is also reasonably logical, and I think we'll talk about best practices and what we should do about this. But this one says that the local physician has to say, hey, can you help me here, please? This often happens when there's an out-of-state referral, right? A physician in Mississippi went to medical school with a specialist in pituitary glands and calls that specialist and says, hey, I got a patient that needs your help. And there comes the second opinion. And this one, again, the way you have to deal with a statute like this is you have to document it. And the way we suggest you document this is with a form letter, if you will, or a form email that says, thank you for requesting my help with this patient, And then we would like for you to get that signed by that local physician. So it doesn't necessarily mean that the physician has requested before the fact to get you as basically to ask you to give a second opinion, but they must make that request somewhere before you, in fact, start to provide the practice of medicine to that patient. And that can happen via this kind of letter in between. Now, if you can't get the local if there is no local doctor that you know of, or you can't get a local doctor to issue that, then I would suggest you not go forward in a state like this. And we can talk about that. This usually is not an issue, but very important that you document it, that you include it in the case record so that you have it on file, that the doctor has in fact requested that you participate.
Yeah, good clarification. Okay. So Montana is a little different in that you can issue an opinion without the inclusion of the local physician. So this is interesting. There are 3 states that have this exemption.
There are 3 states. 2 of them are reasonably geographically proximate to each other. So it's interesting there. But there are 3 states that do this, so it's not a big predominance of states. There were more in the past, but this permits a local physician. And when we say local physician, without a local physician, when we say there's a physician that can issue a second opinion, by the way, that physician must be in good standing in their own state. So they must be duly licensed in good standing in their own state. So this can't be a charlatan that's parading around as a physician. So they must be duly ordained as a physician in their state. And they can, in fact, in Montana, at anybody's request or at nobody's request, issue a second opinion to a patient there without having the local physician. My suggestion is involve the local physician anyway. Ask the patient who the physician is that you should talk to. Put that on record. Put it in the case. But the law is very clear here that doesn't require that.
Great. Okay, so generally speaking, we have 49 states that have some level of exemption. We have 5 states that we've said, avoid or they're prohibited at some level. And some states that have frequency limitations. We've seen some trends emerge and things change over time as we've come post PHE and these episodic exemptions have been defined and redefined. Some of them, I know I've noticed, I've seen more specific definitions of what qualifies as episodic care. Iowa, for example, has now limited episodic practice to 20 days per year. And then others expanding on maybe what's permissible after, like continuity of care. Idaho had the exemption for virtual consultations after an initial consultation. So some really interesting things happening. Can you summarize some of the key trends you've seen? You've been following this closely, and maybe what it means about where things are going?
Yeah. So I think it's pretty clear that states care, state legislatures care. They care about their constituents mostly, and they know that those constituents often need or want specialists that are outside of their borders. So they're trying to create ways to make that happen. At the same time, they're trying to avoid fraud. They're trying to avoid mistreatment of their patients. They're trying to ensure that this gets done right. And they're also trying to ensure that the patient has some continuum post a medical recommendation that's made. They have some way to follow up on that local to them. So with all that said, what we generally suggest is that you involve the local physician, that you get the local physician in every state, in every case that you get involved with, to request that your involvement. So we suggest that you put that in place so that there is documentation in the file. Again, we don't see a lot of pushback from local physicians who acknowledge you as an expert and say, yes, I would like you to help me with this case. Second opinions are pretty prevalent these days, and physicians, for the most part, don't object to you as a patient when you say, hey, thanks for the first opinion, but I want a second opinion from a specialist at in a different institution. That typically is very acceptable today. If it's not, get yourself a new local physician, but it's acceptable today, but document that. And we think if you go to I call it the lowest common denominator, or the most conservative approach to the law, which is in every state, get the local physician to request your engagement as a specialist, put that in the file, you'll be off the hook. No more getting spooked by that case from Idaho. And you'll be in a position where you can issue second opinions. In some states, it'll be limited to a certain number, and there'll be, again, we can document what those numbers are in the various states, but it'll ensure that you are in compliance with their local laws.
Great, thanks. Well, you jumped right into my best practices slide, so that was a good segue. I think, if anyone wants to dig deeper into specific areas or states that they're interested in, we're happy to review those more closely with you. We do that all the time. A question did come in, Les, which is also a good segue because it gets into international law. We do have webinars specifically about international, but it always comes into the conversation. So this question is, hello from your northern neighbors. So hello, those in Canada. Would these rules apply to Canadian patients? I think I know the answer, but go ahead.
So the short answer is these rules and more apply once you step over the border into Canada, and that's not due to any recent things that have occurred, which have perhaps muddied the relationship between the two countries. So in Canada, PHI is very carefully monitored. And it's monitored by province in many cases. So PHI, private health information of a patient. So a physician who is going to, say, a US-based physician who's going to issue an opinion to a patient in Canada, not only do they have to worry about licensure, which is dealt with on a province-by-province basis, but they also have to deal with data residency. So data residency, once you get into international waters, is another issue. And that is where that patient information can go or where it has to remain. And so many countries, in fact, I wouldn't say most countries, but many countries do prohibit the transfer across country border lines of private health information. So if you're going to act, if you're a US-based physician, you're going to act with a patient in Canada, you probably need to act via, I'll call it a cloud-based environment where the patient's information remains in Canada and that you can view it, see it, act on it, but not transfer it locally. So not download it to your machine in the US. Once you've downloaded it to your machine in the US, you have very likely violated data residency laws, which are different, or I would say additive to licensure. From a licensure point of view, I won't go into the specific provinces because they're similar to what we have here in the US, but it is always a best practice to involve a local physician when you're going across country borders as well. So if you're a US-based physician and you're issuing a second opinion to a patient in Quebec, you better make sure that that patient has a local physician. I would love to see them invite you into that discussion. So have that same letter signed by them and leave the data there, act on the data there. And again, we have clients in Canada and can maintain the data for those patients in Canada while it can be acted on by a physician elsewhere. But thanks for that question.
Yeah, that was a really hot topic when I just came back from the Middle East for the Global Health Exhibition in Riyadh, Saudi Arabia, and was part of the USCIP delegation to Oman. And many of the facilities that we visited and the governments, the Ministry of Health that we spoke with, emphasized that point over and over again, because it is new for some of these countries to be putting out their data residency and privacy laws. And they were coming from a technology company. They were really curious how we were handling that and emphasizing how important it was to them. So I think, for those that were pulling data into their local EHR, it's a really good call out and point to emphasize. So
yeah,
go ahead.
There were some comments that were made. So our friends in Canada says data residency is not restricted by law in Canada. It's restricted by contract itself. So they said it's not unlawful. It's just, we'll call it civilly, could be prohibited from that point of view. There was another comment made that nothing applies to the other border right, as in Mexico, we're more free or less regulated to issue opinions since half the patients are private practice. I don't think it matters whether they're private practice or not. I do not know. I'm not familiar with the data residency requirements of Mexico. I'd have to read that carefully, but I would stick with the licensure side of it, making sure that you involve a local physician if you're going to act with a patient in Mexico. And then I would research the data residency requirements if there are any in Mexico. So I don't know if nothing applies there. I'd have to dig into that. And I suggest people be careful with that and just make sure you take a look at it. There are a lot of countries where this is a real big problem. Take the UAE, for example, or Saudi Arabia. Those are prohibited. Now, are they going to come after a doctor in the US? Not while the doctor's in the US. There's probably no extradition for data residency if you in fact have broken the law. But it's not something that you want to engage in on a regular basis, that's for sure.
Right. Well, I would invite everyone to go ahead and add any other last questions or final thoughts into the chat as we close up. I don't know, Les, if you have any final thoughts you'd like to impart on us, or if we want to talk about international a little bit more. I know there's other issues that do come up a lot, like language when you translate, and we can revisit those in another webinar in the future.
Yeah, just a quick mention of language. So language is an issue in many countries, and the best practices that we recommend is that you get the documents, any medical documents, translated in advance of issuing opinion. So if you're going to make a mistake, it's not a mistake in translation, and don't want to introduce that other variable into the equation. And that's pretty much a best practice that we've seen there. But you'll show it up in a minute, but the USCIP conference that's coming up focuses more on international, and I know you'll be there, Samantha, yes, and be running a panel there on that. So there's better information that's coming out there. What I would say, just in closing from this point of view, is this is logical and needed. It is logically necessary for specialized physicians to be able to utilize their training and their, and sometimes unique capabilities to help patients wherever those patients might be. The better you understand the law, the freer you will be to be able to do this. It's not just a commercial necessity, it's a medical necessity to do this. And the idea that somehow, well, I guess at the founding of our country, we relinquished that to the states, that's interesting, but it also has put a pretty big obstacle in front of us. And again, making sure you understand the law carefully, or that your legal team understands the law. We're happy to talk with your legal team to help them understand what we know and point them to the regulations that we have documented. That enables it to be a much clearer path for you.
Yeah, we've had another good question that popped up. Yep. How do episodic exemptions apply to situations like post-transplant follow-up care, which is a regular use for these second opinion programs, transplants?
Yeah, so great question. In certain states, you can't do a follow-up across state lines after a transplant. In other states, you can. there's a very notable case in New Jersey that I know you guys have all tracked, or at least many of you have tracked and talked to me about it. That basically said that this patient that went to, basically a child that went to Boston for care at Boston Children's and came back to New Jersey, that doctor in Boston was prohibited from doing follow-up with that patient in New Jersey, as they would be if this were a transplant situation. So there are more and more states now that are acknowledging that and putting it in their law that there is this follow-up permission in the law, but definitely not every state. In fact, it's not the majority of states that allow that. So it's a tough situation, unfortunately. And that's the again, major reason to have make sure you have a local physician who's well informed as to what's going on. So if that patient goes back, they can get local care for that transplant, which I know is a big task, but that's the way the law reads.
Yeah. What about, to follow up on the follow-up question, what about if they are following up with the local physician? I know one of our children's hospitals does that quite regularly with the local physician. So if they've established the relationship with them, they follow up with the local physician.
It's great. There's virtually no prohibition on physician-to-physician consults, as long as it's not specifically engaged with the patient. It can be about a patient, but physician-to-physician is effectively exempt from this. So in the case of the transplant, could be exactly the same thing, which is patient gets transplant locally, returns back to their state. The consult would then be with the physician, that patient's physician, not with the patient themselves. That's perfectly fine. And in almost every situation, again, with maybe the exception of those 5 states and jurisdictions that we talked about, that would be fine, even without any additional regulations being written into the law.
Yeah, great. Really good questions. Appreciate you all throwing those in here. Good conversations. And so if there are no others, I can go ahead and wrap up here. Did I see another one pop up? Okay, we do have another one. We'll keep going. So what about patient messages through HIPAA compliant text and portals for follow-up? Oh, that's an interesting one. What do you think?
It's an interesting one, but that is dead in the crosshairs of practicing medicine. Any correspondence, whether it's synchronous, asynchronous, written, video, or otherwise, is considered practicing medicine. So unless it's permitted by that state, that is a prohibited practice once that patient returns back to their state.
Okay. Wrote a note to myself. Good to know. Great. Any other questions before we wrap up while we have everyone and Les on the line? Okay. Well, we can always follow up with you if you do, or you can reach out to us. You have our information and we'll follow up with an email with the updated white paper that we've referenced and the interactive map that I dropped in the chat. As we've mentioned, we have a couple upcoming conferences and events coming up. So I and both one of my colleagues here at Purview and myself will be at the USKIP annual conference the first week of December, where we will be addressing some of these international barriers to access and discussing some of those. If you're not a USKIP member, I believe you can still attend. And if you are a USKIP member, I hope to see you there. Then Les will be at the policy conference. That's December 10th through 12th in Washington, DC. And then our next webinar, which takes a bit of a different turn to a new topic, is about using AI to reduce this data overload we are experiencing through this case administration process and really getting to the point of having clinical insight and clarity. It's really exciting. We're really excited about it. So I hope you take the chance to attend that as well. We'll be sending the invite out shortly. Any final thoughts, Les?
One quick thought. Idaho is an in-concert state. So in answer to the question about what that pathologist could have done in Washington, they could have had a conversation post-fact with the patient's doctor. They probably would have been completely off the hook. Any conversation at all with that doctor probably would have gotten them off the hook in Idaho.
Yeah, see, I think these things keep you up at night. You're still thinking about that.
I wrote it down.
All right. Well, thanks everyone for coming again. We will update you in another 6 months. Stay tuned, and we hope to see you at one of the upcoming events next time. Have a good rest of your day and week. Thank you.
Thanks, Samantha.